The United States Supreme Court has issued a massive emergency ruling overriding a lower court's decision and delivering a major victory for Alabama in a high-stakes showdown over congressional redistricting and election law issues. The Supreme Court has officially granted Alabama's emergency application for a stay, freezing the lower court's latest order and clearing the way for the state to move forward with its prepared congressional map for the upcoming elections. But the real shock isn't just the stay order and how it was granted. In the accompanying opinion by the Supreme Court, the court took direct aim at the lower court's handling of this case, criticizing the judges for failing to properly apply recent Supreme Court precedents and disregarding the fundamental presumption of legislative good faith, and also they criticized the lower court of trying to interfere with the ongoing election cycle. But now this case has entered a very critical and new stage. Alabama is moving forward with its effort to secure a final victory from the Supreme Court, but at the same time, a new battle is already emerging over what happens at the lower court level while the Supreme Court considers this case. Because despite the Supreme Court stepping in and freezing the lower court's prior order, the district court believes that litigation can still move forward. So in this video, we need to break down what the Supreme Court did in that order, what did they say about what the lower court did, and what is now moving forward at the lower court level based on what the Supreme Court just did. Now, before we jump into what the Supreme Court did and what is now developing in this case, if you like this type of content and you want to make sure you get it going forward, make sure you like, comment, subscribe, and also turn on all notifications to get these types of videos when I release them. Now, to understand how we reached this explosive breaking point in this case, you have to look at how the lower federal court once again found itself directly at odds with the Supreme Court. This entire battle centers on the Supreme Court's landmark ruling in the case Louisiana versus Calais. That ruling by the Supreme Court reshaped how federal courts must evaluate claims involving race, politics, and congressional redistricting. The Supreme Court made clear that lower courts must carefully distinguish between racial considerations and ordinary partisan politics, respect traditional districting principles, and properly account for the presumption of legislative good faith when evaluating a state's decisions. Now, following that ruling, the Supreme Court sent the Alabama litigation and case back down to the lower court for further proceedings under this new legal framework in the Calais decision. Now, when the case returned, the lower court once again ruled against Alabama's 2023 congressional map. The district court concluded that Alabama had once again acted unlawfully and entered a sweeping order on May 26th, essentially which threatened to keep the state's congressional map that they wanted blocked, and they could not enforce it going forward for the upcoming election. Now, Alabama immediately went back up to the Supreme Court and asked the Supreme Court to intervene immediately, and ultimately the Supreme Court did exactly that. When the Supreme Court granted Alabama's request for an emergency stay, the majority made it very clear in their opinion that Alabama had presented strong arguments against the lower court's ruling. The Supreme Court concluded that Alabama had demonstrated a likelihood of success on the merits for some of its constitutional claims, and the majority then turned directly to what they believed the lower court actually got wrong. First, the Supreme Court criticized the lower court's treatment of the presumption of legislative good faith. The lower court had essentially heavily relied on Alabama's history in this litigation and the legislators' response to previous court orders. But the Supreme Court emphasized that disagreement with a federal court does not automatically prove discriminatory intent, and that the state's legislators remain entitled to a presumption of good faith. Second, the Supreme Court concluded that Alabama had raised a serious argument that the lower court failed to properly apply the Supreme Court's prior precedents and new precedents involving redistricting. Alabama argued that its map better protected the Gulf Coast communities of interest and avoided pairing incumbent members of Congress against one another. Those interests matter because the legal question is not simply whether the challengers can draw a different map. The question is whether they can demonstrate that their alternative map satisfies the relevant legal requirements while also accounting for the state's legitimate and traditional redistricting objectives. But the Supreme Court's criticism of the lower court ruling did not stop just with those arguments. The Supreme Court also focused on one of the most important principles in election litigation, which is the Purcell Doctrine. The basic principle is that federal courts must exercise extreme caution before changing election rules as the election approaches. The district court had reasoned that continuing to use the court-drawn map, the alternative map, essentially could reduce disruption because election officials had already administered elections prior under that court-ordered map. But the Supreme Court rejected the idea that a federal court's preference for maintaining the status quo automatically overrides a state's own decisions about which lawful election map it wants to use. And this is where the ruling becomes much bigger than Alabama. The Supreme Court emphasized a very important distinction between federal courts changing election rules and sovereign states making their own decisions about how they want to administer their elections. Now, based on all of this, the Supreme Court granted Alabama's request for an emergency stay order, so they ruled in favor of Alabama. So in practice, this allows Alabama to move forward and use their desired map during this upcoming election cycle, and they can continue to use that while this litigation moves forward. However, new things have developed after that Supreme Court emergency stay order, and some of these developments are very interesting. After the Supreme Court entered that stay order, activity continued at the lower court level, and that is where the new battle currently is happening. The parties filed a joint motion asking for the lower court to extend the deadline for proposing discovery limits, expert report schedules, and other case management deadlines. So on the surface, that kind of sounds like routine scheduling. But also buried within this procedural arguments is the fact that Alabama is saying that the lower court should not be moving forward with this case while the Supreme Court's merits case is still pending. The plaintiffs who are opposing the Alabama congressional map appear to be treating the Supreme Court stay order that was just issued as a pause on the immediate effect of the May 26th ruling, while still allowing the lower court to keep building the case in the background. But Alabama contests that and they say no, that should not be happening. Alabama's position is that if the Supreme Court stayed the May 26th order, then the district court cannot keep enforcing the discovery schedule and moving this case forward while the Supreme Court case in that review is still pending. If Alabama is right, the lower court proceedings should largely stop while the Supreme Court's merits review plays out. The state should not be forced to spend time and resources preparing for more discovery, expert reports, and another trial while they're also moving the case forward at the Supreme Court level, seeking for the Supreme Court to wipe this out entirely. But if the plaintiffs are right, if those individuals opposing Alabama's map are correct, well then the lower court can keep this case moving forward kind of on a parallel track so that if Alabama loses at the Supreme Court level, the case is already positioned to move quickly in their favor. So now the fight is not just about the map itself, it's also about who controls the pace of the lower court litigation while the Supreme Court is reviewing this case as well. Now this matters because emergency Supreme Court stays are not supposed to just be meaningless. Alabama argues that when the Supreme Court stays a lower court order, the losing side in the lower court cannot simply continue enforcing the practical machinery of the litigation of that same order as well under just simply a different label. If the district court disagrees, well then Alabama may have to either litigate below also while they're litigating above at the Supreme Court and seek additional relief to stop that lower court proceeding potentially. So this case now has two tracks and it's getting messy based on the plaintiffs and potentially the lower court's continued efforts to try and stop Alabama's current desire for their specific redistricting maps and how they want to proceed forward with their election. So the Supreme Court has already stepped in and stopped the lower court's May 26th order from taking effect, but now the next fight is over what that stay actually means. And depending on how the lower court responds, Alabama may not just be fighting over its congressional map. It may also have to fight to stop the district court from continuing to move this case forward and maybe issuing a different order that just throws, another wrench into this whole process and causes even more issues. So that is what is currently developing in this election law case after that Supreme Court grant of the emergency stay request. If you like this type of content and you want to ensure that you get updates on this moving forward, make sure you like, comment, subscribe, and turn on all notifications to never miss these videos when I release them. But as always, thank you so much for all of your support. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.